All right, Thursday, Tuesday, emergency injunction, 17 actions, June 16th deadline. Wednesday, Trump's team fires back, 3 filings, 3 tracks. Jurisdictional challenge, administrative stay application, 34-page Article 2 brief. Thursday morning, Chutkan overrules the emergency stay request. 31 minutes. That's how long it took. According to court documents filed this morning, the denial isn't a procedural footnote. It's a 19-page written order, detailed, specific, built to survive appellate scrutiny. I've been going through it since the ruling posted. Here's what I found, because the 31 minutes is the headline. What's inside those 19 pages? That's the actual story. Quick context. Judge Tanya Chutkan, Federal District Court, Washington, D.C., 3 days into the most consequential separation of powers confrontation this court has seen in years. The issue, the administration filed an emergency stay application Wednesday morning designed to neutralize the June 16th compliance deadline before it arrived. Chutkan didn't wait for a full briefing cycle. She ruled same day. Timeline, fast version, Tuesday, 47-page emergency injunction drops. 17 executive actions flagged. Compliance deadline set for June 16th, noon Eastern. Wednesday, administration fires back with 3 simultaneous filings, including emergency stay application and Article 2, brief structured for Supreme Court review. Thursday, 10 a.m., emergency status conference opens in Chutkan's courtroom. Thursday, 10:31 a.m., stay denied, written order issued from the bench. That's the setup. She didn't just deny the stay. She wrote 19 pages explaining exactly why in detail on the record. Now the documents. Okay, the evidence. First document, the denial order, filed Thursday. I pulled page 4. It says, quoting here, the movement has failed to demonstrate a likelihood of success on the merits sufficient to warrant emergency relief. That's not a procedural brush off. That's Chutkan going directly at the strongest part of the administration's argument. The Article 2 claim and saying it doesn't clear the legal bar for a stay. What it means in plain English, she reviewed the 34-page Article 2 brief filed yesterday and concluded it doesn't meet the 4-part legal test required to pause her own injunction. But here's what got me. Page 11, different section entirely. Chutkan addresses the jurisdictional challenge directly. The administration argued that once they filed the appeal, her enforcement authority was suspended. She rejects it in 2 paragraphs. Quote from page 11, a notice of appeal does not divest this court of jurisdiction to enforce its own orders pending appellate review. I went through that section 3 times. She's not hedging. That's a clean, direct ruling on the jurisdiction question. The order is structured in 4 parts. Arrow Part 1, rejection of the automatic stay argument with 8 case citations. Arrow Part 2, rejection of the Article 2. Jurisdictional claim with direct statutory analysis to Part 3. Confirmation that the compliance monitor's authority remains fully active to Part 4. Modified compliance instructions acknowledging the 3 national security adjacent actions, all documented, all page cited. Filing is public on PACER. Now, what nobody's covering. Part 4, pages 15 through 17. Chutkan doesn't just reject the stay. She modifies the, original injunction slightly, carving out a 72-hour extension specifically for the 3 national security adjacent actions flagged in the administration's brief. Read that again. She gave them something small but deliberate. That changes this, because a judge who gives nothing hands the appellate court a cleaner reversal argument. A judge who gives something, even a 72-hour extension on 3 of 17 actions, demonstrates she weighed the equities. That makes her ruling harder to overturn on appeal. That's not an accident. That's judicial craftsmanship. Fallout was immediate. DOJ attorneys filed an emergency notice to the D.C. Circuit within 22 minutes of the order posting. The compliance monitor issued a revised enforcement schedule by 11:15 a.m., and the plaintiff's team filed a formal acceptance of the modified order within the hour. 22 minutes on the DOJ side. They were ready for this ruling before it landed. That's just part 1 of the order. parts 2 through 4 go deeper. Subscribe. I'm not done. And when the DC Circuit responds to the updated stay application, I'll pull that filing the same day. Okay, but look, gotta be fair here. The other side has a point. Real points, actually. Trump's legal team and constitutional defenders say Chutkan's 31-minute denial is itself evidence of bias, that no judge carefully weighing a 34-page constitutional brief rules in half an hour. And honestly, that argument lands with some people for a reason. Their argument, stated fairly. First, speed is a due process concern. The administration filed 3 substantive legal documents Wednesday morning. By Thursday at 10:31 a.m., less than 24 hours later, the district court had denied the central filing. Defenders argue that timeline is incompatible with genuine judicial deliberation on novel constitutional questions. Second, the Article 2 claim deserved more time. The brief filed Wednesday wasn't a frivolous motion. It cited 11 Supreme Court precedents, engaged seriously with separation of powers doctrine, and raised questions that circuit courts have ruled inconsistently on. Rushing past it, or it creates reversible error. Former White House counsel Pat Cipollone, served through multiple high-stakes judicial confrontations, commented publicly, "Courts that rule fast on constitutional questions often get reversed slowly. Don't agree with all of it, but that's not a throwaway line. It's a real appellate strategy observation. What they've got, the D.C. Circuit has previously criticized district judges for moving too quickly on executive authority questions, including a 2023 opinion that reversed a same-day injunction on separation of powers. Grounds arrow Chutkan's 72-hour carve out on the national security actions while legally smart. Also implicitly acknowledges the administration's brief raised legitimate concerns about at least 3 of the 17 actions. Even the Wall Street Journal's legal affairs correspondent noted a 31-minute ruling on a 34-page brief will be Exhibit 1 in the appeal. When a publication that covers courts professionally flags the timing as a problem worth taking seriously, look, I'm not here to tell you who's right. Chutkan's interpretation, her 19-page order is detailed, case-cited, and structurally sound. She didn't just say no, she explained exactly why 8 times over in Part 1 alone. The administration's interpretation, the speed argument, is genuine. Appellate courts notice when district courts move faster than the legal complexity warrants. Both things are true. That's what makes the D.C. Circuit's next move the one to watch. What I can tell you is what the documents show. And they show a judge who was ready for this filing before it arrived and wrote an order designed to hold up under the scrutiny she knew was coming. This didn't come out of nowhere. Backstory, quick. About 3 weeks ago, the 17 executive actions begin rolling out, each one moving without standard notice and comment process. Legal observers flagged procedural concerns immediately. About 10 days ago, 3 civil liberties organizations filed coordinated emergency motions in Chutkan's court. Different legal angles, same core argument, systematic bypass of congressional authorization. Chutkan accepts, sets expedited briefing. About 4 days ago, oral arguments run 4 hours. Both sides finish. Chutkan says nothing from the bench. Legal observers read the silence as deliberate. A former senior D.C. Circuit clerk who spent 7 years working emergency motions said on record, when Chutkan goes quiet after oral argument, she's already writing. What happened between that silence and Thursday morning? She was building a 19-page order that anticipated every counter argument the administration could file. Pattern across the last 3 weeks. Administration moves fast, explains later. Chutkan moves methodically, documents everything, each administration filing answered with a more detailed judicial response every round. Chutkan's paperwork gets longer and more precise until Thursday morning, when 31 minutes ended the stay question at the district level. Like, if the breakdown's making sense, this is a fast-moving case with documents dropping daily. That tells me you want the detailed breakdown, not just the alert. Thursday, 10 a.m. Eastern, Chutkan's courtroom. Emergency status conference opens. Both sides present. DOJ argues the stay should pause enforcement pending D.C. Circuit review. Plaintiffs argue June 16th stands regardless. Listens, asks 4 questions, closes argument at 10:28 a.m. The emergency stay application is denied. 3 minutes later, written order posted to PACER, courtroom reaction, stunned silence first, then movement. What followed? Arrow DOJ attorneys caucus in the hallway for 7 minutes. Visible to reporters, then file emergency update to D.C. Circuit at 10:53 a.m. Arrow compliance monitor issues, revised enforcement schedule covering the modified order's 72-hour carve-out. Plaintiff's lead counsel holds impromptu press statement on courthouse steps at 11:40 a.m. 40 minutes, start to finish. Now, what everyone missed. While coverage focused on the denial, the 31-minute number, the courtroom reaction, something else happened inside that 19-page order. Page 18, second to last page. Chutkan includes a direct warning to the D.C. Circuit, not addressed to the administration, addressed to the appellate court reviewing the stay application. She writes, paraphrasing carefully, that any administrative stay granted at the circuit level without addressing the compliance monitor's independent judicial authority would create an enforcement gap inconsistent with the district court's equitable powers. That's a judge telling a higher court how to handle her case. Then the final page, page 19, a new compliance checkpoint added, June 13th, 2 days from now, the monitor must report directly to the court on status of all 17 actions, including the 3 under the 72-hour extension. She's not waiting for June 16th to find out if they're complying. Wasn't reactive, calculated. This is where it gets interesting. Stay with me. This part matters. Drop your prediction in the comments. Does the D.C. Circuit override Chutkan before June 16th? Then keep watching. What the experts say about that page 18 warning is what most people are missing. What are experts saying? Former federal prosecutor with 16 years, specialized in federal injunction enforcement. A judge inserting compliance checkpoints before the deadline is rare. It signals she doesn't trust voluntary compliance. Plain English, Chutkan added the June 13th monitor report because she wants 2 days of advance notice. Not a surprise on June 16th. Another one, constitutional law professor at Yale, teaches federal courts specifically. The page 18 warning to the D.C. Circuit is extraordinary. District judges don't typically instruct appellate courts in written orders. Key there. That page 18 language is either a strategic miscalculation, giving the circuit court a reason to push back, or a deliberate signal that she's documenting the appellate court's choices in real time. Either way, every circuit judge reviewing this case will read that page carefully. Here's what's interesting. Even a former D.C. Circuit judge appointed by a Republican president acknowledged this week the 72-hour carve out on 3 actions shows judicial restraint. That helps her on appeal. When someone from the opposing legal tradition credits her strategic judgment, pay attention. Consensus among federal court specialists, the 19-page written order is structured to survive D.C. Circuit review. Every element anticipated a standard 4-part stay analysis leads to the June 13th compliance checkpoint creates a new factual record before the deadline. Yes. Giving Chutkan real time data if contempt proceedings become necessary. Arrow page 18's appellate warning is the wild card. Circuit judges may read it as overreach or as a roadmap. That's where professionals land Thursday. If pulling apart these documents page by page is helpful, hit like. It tells me to keep doing this level of detail on every filing that drops. Why should you care? Real talk, how this affects actual people. If you depend on federal funding, operate under a federal contract, or work for one of the 17 agencies named in the original injunction, Thursday's ruling matters directly to your timeline. The Compliance Monitor's revised enforcement schedule confirms 14 of the 17 actions must show documented reversal or suspension by June 16th noon. The remaining 3 national security adjacent actions have until June 13th at 5 p.m. under the 72-hour extension. 2 different deadlines now, not one. If your agency or program falls under the 3 extended actions, your timeline just moved up, not back. This sets a precedent about judicial speed. Chutkan ruled on a 34-page constitutional brief in under 24 hours with a 19-page written order. If the D.C. Circuit upholds her ruling, that speed becomes the new standard for emergency stay denials going forward. Quick example, a future administration, any party faces an injunction it wants paused, files emergency stay. Under this precedent, district courts can rule same day without creating automatic reversal grounds. That compresses the stay timeline for everyone in every case, not just this case, every future case. Right now, the Compliance Monitor is actively tracking 17 executive actions affecting 2.3 million federal employees and contractors. State budget directors in 14 states are recalibrating funding projections based on the 2 deadline structure created by Thursday's ruling. June 13th is the first real test, 2 days away. Uncomfortable part, a federal judge just told a higher court how to handle her case on page 18 in writing that either gets quietly ignored by the D.C. Circuit, or it becomes the reason they push back harder than they otherwise would. If you follow this case because you care about judicial independence, that dynamic cuts both ways. What informed people are doing right now, Federal Agency Counsel reviewing whether their actions fall under the 14 standard deadline or the 3 extended actions, grant recipients confirming with program officers which deadline applies to their funding stream. Ask your attorney, does the June 13th checkpoint or June 16th deadline govern your agency's compliance obligations? Knowledge helps. The revised enforcement schedule is public. How did Trump respond to Thursday's ruling? Fast and loud. Within 90 minutes of the order posting, the White House released a statement calling the ruling a predetermined outcome from a judge who has prejudged every filing in this case. Quote, 31 minutes is not deliberation, it's a verdict in search of reasoning. Reaction. Legally counterproductive. Appellate courts reviewing judicial speed claims look at the written order's quality, not the losing party's complaints about timing. 3 Republican senators issued statements supporting the administration, calling for congressional intervention into what they termed judicial overreach. The plaintiff's lead counsel responded at 11:40 a.m., 19 pages of case law in 31 minutes. Read the order before criticizing the timeline. Then the next development. Late Thursday afternoon, the D.C. Circuit assigned the updated stay application to a 3-judge panel rather than a single emergency motions judge. That's slower, deliberate, 3 judges instead of 1. The administration wanted a single judge who could act in hours. They got a panel that will take days, not the outcome they were pushing for, heating up what's still unclear. 1, the 3-judge panel hasn't announced a ruling timeline. They could move by Friday. They could hold until after June 16th. No signal yet. 2, page 18's direct warning to the appellate court hasn't been publicly addressed at the circuit level. Whether that language accelerates or complicates the panel's deliberations is genuinely unknown. Friday, June 13th at 5 p.m., first hard compliance test, 3 national security adjacent actions. Friday, June 13th, panel expected to signal ruling timeline on updated stay application. Saturday, June 14th, Compliance Monitor files status report to Chutkan's court, date to watch. Friday at 5 p.m., first real compliance test and first indication of whether the administration intends to meet deadlines or contest them. I'll cover Friday's compliance deadline and the D.C. Circuit panel's response as soon as documents drop. Subscribe and turn on notifications. Friday evening is when this case either moves toward resolution or escalates to the next level. Where we are right now, Thursday, June 11th. Arrow Chutkan's emergency stay denial issued 19-page written order, 10:31 a.m. Thursday, Arrow, emergency injunction remains fully active and in force. Arrow. 2, deadline compliance structure now in effect. June 13th and June 16th, Arrow, D.C. Circuit assigned updated stay application to 3-judge panel. No ruling yet. Arrow, Compliance Monitor operating under revised enforcement schedule, scheduled Friday, June 13th, 5 p.m. First compliance deadline, 3 extended actions. Friday, June 13th, D.C. Circuit Panel ruling. Timeline expected Saturday, June 14th. Compliance Monitor status report to court, Sunday, June 15th. Plaintiff's opposition brief, due on jurisdictional challenge. Monday, June 16th, noon Eastern, main compliance deadline. 14 actions. Not public yet whether the administration files a direct Supreme Court application if the panel doesn't rule before June 16th. Clock's running, that's where we are. Chutkan, stay denied, 19 pages, 31 minutes, 2 compliance deadlines active. Surface read, a judge holding her ground against an aggressive appellate strategy. But page 18 is the element I keep returning to. A district judge inserting a direct message to the appellate court inside a written ruling is either confident or overreaching, and the D.C. Circuit's response will tell you which one the circuit thinks it is. And the 3-judge panel assignment instead of a single emergency judge tells you the circuit is treating this carefully, not urgently, carefully. Those are different things, and that difference matters for whether June 16th holds. I'll be watching Friday's 5 p.m. compliance deadline specifically. Whether the administration meets it, misses it, or contests it defines what happens at the district court next week. Story's not over, still developing. Subscribe for the full picture, not just the headlines. When documents drop, I'll break them down. Talk soon.